up everyone, it's the Law School Lumberjack. I hope you're having a great day. Today we're going to do another installment in our Property Law 101 Fee is Not Simple series, and today we're going to be talking about the doctrine of waste. So this installment is just meant to be a brief primer on the types of waste one might see. So waste is defined as an action, or I guess it could be an inaction, that causes injury or does lasting damage to the value of a property. So as you know, a life estate tenant holds property to have and use, so they possess the property for their lifetime. Now, concurrent with their interest oftentimes is the right of a remainder man, who gets the property in fee simple once that life estate ends or once the life estate tenant passes away. So with the rights of that life tenant come with it certain responsibilities. And these responsibilities are generally negative rather than positive. And what I mean by that is this: unless there is something in the grant that requires the life estate tenant to take some action, generally a life estate tenant is not required to take action to prevent waste. However, at common law, a life tenant does have a negative obligation in that they are not allowed to cause waste to the property. So they're not allowed to take action that causes waste, but they don't necessarily have to prevent waste. So depending on what report, commentary, or textbook you're reading, there are generally kind of four types of waste, or four categories of waste. And with each of these types of waste, there exists a remedy or a lack of remedy for that type of waste. So the first one we see is a permissive wastage. And what this means is it's a failure to act. So the life tenant is living in the property, and let's say the roof starts leaking. Unless there is a requirement in the grant that imposes a duty on the life tenant, presumptively the life tenant is not responsible for those repairs, even though it could eventually damage the property. Instead, it is the remainder man's responsibility to repair the roof. The second type of waste we see, and again the nomenclature may be different depending on what textbook you're reading or what report you're reading, is a voluntary waste. And that is where the life tenant purposely does a wrongful act that reduces the value of the land. So this would be a situation, for example, where the life tenant demolishes a valuable building on the property, or in Old England, if they lived on the land and there were crops or trees on the property and they felled some of the trees or took some of the crops, that would be considered a wrongful act. In those circumstances, the remainder man could seek damages against the life tenant at law. Additionally, in equity, the remainder man could seek an injunction against the life tenant to prevent him from doing those acts further. So what an injunction essentially is it's a court order that either forces a party to do something or forces a party to not do something. Now, we go into the third type of waste, which really falls under the second category. It's just a more severe type of the second category, which is an equitable waste. And this is essentially a severe and malicious destruction of property. So for example, if the party near the end of their life is saying, if I can't have this property, no one can have this property, and takes a sledgehammer to the property, that would be what one would consider an equitable waste. The life estate tenant would likely be responsible for the damages to the property, but even if they weren't for some reason, there would be the opportunity for the remainder man under equity to seek an injunction to prevent the life tenant from causing further damage to the property. So the last type of waste we see is what we call ameliorating waste. So that's a situation where a party benefits the land by taking a certain action that may be considered waste. So for example, I previously explained a situation where a party destroys a valuable building on the property, and that could lead to damages against the life tenant. With ameliorating waste, we would have a situation, for example, where there is an eyesore on the property, maybe an old decrepit shed, and the life tenant goes in and destroys that shed. Now, by destroying it, it actually increases the value of the property because the property is no longer an eyesore. So it actually does a net positive for the remainder man. Now, even though the life tenant stepped outside of their bounds and weren't supposed to destroy property on the land because they have a responsibility to keep the land in good shape and in the reasonable condition it was when they received the life estate, by increasing the value of the property, it really arguably precludes the remainder man from seeking damages against the life tenant, because the life tenant would just say, what damages? I've actually made you money. And also, it's very questionable whether or not, if someone caught wind of this and tried to prevent the life tenant from taking down the shed, whether a court would in fact grant the injunction, because it's hard to prove any harm by doing something that benefits the land and increases the value of the property. So I hope this video was helpful. Again, this is just meant to be a brief summary on the types of waste one might see and the remedies available. If this video was helpful, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. See you next time.